Okay, I think if it's okay with everybody, can I check with Ogilvy whether we can start now, Tony? I think we can.
Yeah, I think we can start.
Okay, right, lovely, thank you. May I just make a small appeal to all of us just to switch off our microphones so that we don't get any unnecessary interference. And I know we will forget to switch it on before we speak sometimes, but that's normal for all of us, but we'll get there. I want to thank everybody for their attendance today. As I indicated, I am standing in for Mr. Raj Badal of Verulam, Durban area, and I apologize, is just unable to be available because of urgent commitments. If there are any specific apologies from anybody that wants to note it, please feel free to put it on record at any time, as you may remember. So let me continue with the welcome. I want to just welcome the CEO of the LSSA, Tony Pillay, the Director of LEAD, Ogilvy, Ramashoba, and also members of the EXCO of the LSSA. I know Etienne is closely involved with education as well and training, and so welcome to him and other members of EXCO. I may not be able to pick them up off the long list, and so I can see old friends there, Emil, Henry, Titi, Muzi, and Donovan, and others. So, and many names of the schools, representatives of the principals and principals themselves, tutors, and all of you are very warmly welcome. And also thank you for making the time in these very difficult times that we are going through, both in terms of COVID and also in terms of the uprisings that have taken place in parts of our country, in KZN and Gauteng in particular. We hope that those simmering tensions that are still on the boil will be in some way calmed down and a sense of recovery can be put in place. And I'm sure that our legal profession and all its collective agencies will play a part also in that process. I want to deal next, I would turn to the issue of why we are engaging in this process of this webinar. And I don't want us to dwell too much on what may have been the odd little problem, which we've already dealt with, namely, there was a little bit of a blip or a bump in the road in relation to one of the papers in November 2020, where there was a drop in the pass rate, and there were certain queries raised about the paper and its contents, and it took candidates by surprise. But I think we've properly addressed that over the past months, and we've moved forward. And I think we've also put in place certain processes that would prevent this type of occurrence going forward. I also want to say that this is an important initiative that has been put in place by LEAD, and it is something that I believe will be ongoing, so that we are in a position to carry out these, what I will call, quality control checks and support systems as well, for everybody from examiners to tutors and all participants in this value chain of legal education for the purposes of successful outcomes for all candidate legal practitioners. And I must also underline the work that LSSA and LEAD is doing in fulfilling the important mandate that the Legal Practice Council carries, which it is unable to do in terms of its own resources and its own structures, and that is to provide legal education and training. It's an imperative in terms of the Act for the Council to carry out, but as we know, it's, if one has to say, it's been outsourced in a productive way to the important stakeholders that have been carrying the burden of training candidate legal practitioners for the past decades. So the importance of LEAD and the LSSA must not be forgotten, as I've often asked people to remember it and remind ourselves that the LPC is also indebted to LEAD in many respects for the work it has been doing in training candidate legal practitioners. The process going into this meeting, I'm sure it's not going to be too complex, but it's an ideal opportunity for all of us in this webinar to engage and to support one another and the system of PVT training, and identify what we can do to improve and to deliver what we may say an even better product going forward. Insofar as the documents that have been sort of placed before us in the attachments that Ogilvy had sent out by email, I want to just confirm that we will be dealing with the questions and issues that we would want to focus on today. But amongst the attachments are sample papers. I think Ogilvy put in the the November 2019 papers just to illustrate certain things. And then there's a spreadsheet that's attached, which gives a fairly good indicator of the type of percentage passes. And if anything, apart from the little blip in November 2020, I think we can see that there is a certain normality, if I have to use that word, that's been re-established in terms of the way we have looked at the results and how they have sort of emerged from the more recent examinations. So Ogilvy will speak to that, or anybody else. And I would like to just before we go into the issues, just a few, maybe don't want to call it housekeeping, but just some guidelines. We probably are close to 40 people and we may get more. I think Tony can keep us updated, but if there's a problem in getting yourself heard, I know we're going to use the raising of hands as well, but we encourage that participants to use the chat sort of medium that's there. I know there's a little icon at the bottom where if you look at, it's like a circular thing with something or the other, and you can type your message. So I see there was a message from Mr. Harmon. I'm not sure if the presenter is not audible or is it my network? That's an important question. Is there anybody who's having a difficulty in hearing me, or if you are having a problem with the network, please indicate so that Ogilvy, and I must thank Grace also for being around. She is going to coordinate putting up material on the screen to share on our screens that we may need to refer to from time to time. And she will remove it from the screen once it's over, as it were. So we can use the hand raising method and the chat. And if all else fails, I'm not one that sits on ceremony, as you would know. Please speak, and you can. It's not regarded as rude or an interjection, but please say, just come in and we'll recognize you, and we will then be able to talk through the issues as well. So you have got various options. I will now say those are my opening remarks. If there are any matters, I think I must mention, Ogilvy did say that there was an apology from Ashwin Trikamji, as you know, who's national convener for the exams and so forth. He attends a meeting, unfortunately, on Wednesdays with, I think, some national department in government. So, so that's the only significant apology that I could recall. So, can I ask, before we go into the questions, I just want to open this introduction to anybody if they have any thoughts or comments or additions. Please, you're free to come in at any time, so you don't need to do it right away if you don't have anything at this stage. But I'd like Ogilvy to just indicate whether he would be in a position to, or Grace, whether we should screen share the first attachment, which sets out certain questions that we need to address, and to share it on the screen so that it's easier for us to follow. Tony, is there anything on your side?
No, Krish, I just posted a message to welcome Melissa Murray, who's the National Manager of Legal Education at the Legal Practice Council. I did post it on the chat.
Oh, thank you. Thank you very much. Welcome, Melissa. Right. If there's, right, thank you very much for that, Grace. As you will see, I'm sure Grace put it on and it will be quite easy. Yes, now it's much clearer. If we are all in agreement, I think that let's also bear in mind that we are not in a position to speak for the quality of candidates that come to the schools and for the candidates that sit for our exams in terms of their prior education and training. And I want to just put that as a as a kind of background point that we should, as a reference point, that we unfortunately do not control the quality of education that is going around in the universities and those that even emanate from the high schools, the system, the standards, the quality, and at the tail end of it all, a graduate comes out of university with a law degree and gets articles and has to be trained as a lawyer. And the legal profession for many, many years, during the days of Nick Swart, had developed systems at the PLT where they are supplementing the weaknesses that exist even at the LLB law degree level in brushing up and attending to numeracy and literacy issues and so forth. So I do not want us as the LSSA or LEAD to feel guilty about anything or to have anybody else inflict a sense of guilt about pass rates, about the standards that are in place already. I just wanted that to be put as an underlying thing. We as LEAD and LSSA and all the hard work the tutors, the trainers, the examiners are putting in, they're doing it because of their deep commitment to overcome the legacy of the past, the poor quality of education under the present 27 years of our democracy, and or 24 years, I'm getting lost in the count these days or whatever. But the point is this, that we still carry that legacy and we are still pitching in to do our bit to assist the candidates who are at the receiving end of all these problems. So our work is constantly under scrutiny and self-examination, and I think we should all be proud of the work that the PLT has been doing and continues to done under the legal and continues to do under the present Legal Practice Act as well. Thank you. The meeting then is open to everybody, and Ogilvy, you're free to step in and to take us through the questions as they are on the screen. I don't expect the meeting to be too long, but it's up to all of us to see whether some or other of these questions require additional information or inputs and submissions. So the first question is, did candidates do better or worse in any of the 4 exams? And if so, which exams and which subjects? I'm not sure whether we're in a position to do a detailed analysis of it, but if there's an overview of it, Ogilvy, do you want to take us through that?
Thank you, Chris. I think the exam where students actually performed are below 20%, where the statistics of the exam were actually below 20%, was the November 2020 exam, and that was paper 3, which was the ethics paper. That is the paper that actually, those are the results that actually prompted certain structures within the LSSA to actually invite all stakeholders to try and drill deeper to find out where the problem might have been, and also to assess whether the training that we offer at our practical legal training schools and also at our courses were actually addressing the standards with regard to our practical training.
So Ogilvy, we have covered the issue of the November 2020. Would I be correct in suggesting that we have re-established what I would call the kind of normal pass rates, and that there's nothing that stands out in relation to any of the provinces. I'm always keeping in mind the issue of COVID in the background, but so we don't need to make a specific reference to it because COVID is COVID throughout the country. But if there is there anybody with a comment or
yes,
yes,
if I may.
please.
Thank you, Krish.
Yeah.
I have been involved in attorney's practice and getting the candidates ready for the examinations for quite a number of years. You already mentioned the bumpy road, Krish, early on, particularly in November 2020. And one of the questions concerned the business rate. A lot of the candidates came horribly short. I have the following comments to make and perhaps to suggest how we could improve. But let me compliment, first of all, LEAD for changing the style of questions that have been asked before. At one stage, long questions for 20 or 25 marks, draft suretyship agreements, etc. I believe that prepared future lawyers to go into a medium practice or in one of the top firms in South Africa. It wasn't focused on your one-man concern. Very small margin of the questions asked in the past concentrated on legal ethics. I have seen a trend in which I believe that shorter questions are being asked, covers a wider range of questions that concentrates on practice. And I want to commend LEAD, whoever the examiners are, for changing the style then. I believe that our candidates are better prepared then to write the exams and go into practice and ultimately to start their own practices. So that is one aspect. The big concern I have is the following. The time reduced remarkably at the night schools, where we have a 4-hour session with the candidate legal practitioners. And I hasten to add that it is not enough. We must seriously consider perhaps increasing that to 8 hours. I have had the benefit of now recently being asked by the Law Society to prepare the candidates for the, or it was part and parcel of the training of candidates. I've also been involved in NADEL, a special training course which we got off the ground, especially after what we call a COVID-20 paper. That was the November 20 paper with Business Rescue, as I said, included in there. And I must say that we have, thanks to NADEL, we have increased the pass rate in the succeeding exams or so. But also insofar as the day students are concerned, your 5 weeks and your 2-week course or so, only 2 hours are allocated for the subject matter. Over the weekend, in preparation for the forthcoming exams, spent 9 hours, and I just got through the whole syllabus as well. So I urge those who can perhaps affect changes that the hours should be increased. Thank you.
Thank you very much, Professor Henry Lerm, and we're all proud of your new position at the university, and we're sure you're going to make an even bigger contribution with the many, many more years that you still have to serve us. Thank you.
Thank you, sir. Thank you. I'm warmed by that.
Thank you. Etienne, I recognize you. You have your hand up. Please go.
Thank you, Krish. Good afternoon. Thanks, Krish. And I think LSSA lead in general for the opportunity. It's good that we do a bit of introspection. I think that it's important to realize why this process is necessary. You know, we are a service provider to the LPC, and as such, you know, one should not take a comfortable position. You should rather take a very ethical approach about that and say, how can we improve and constantly improve and up our game? And I think I would like to see a process like this unfold to ensure that we move towards, you know, even better champion status as far as legal education is concerned. And if we can take some pointers out of that today and move forward and know where to develop and what to improve, that'll be excellent. I just want to say on as far as the papers are concerned, if you look at those statistics, I know we're all focusing on, or we have mentioned a lot about November, and I might want to say something about that, but I don't want to focus on that now, and rather just say that if one looks at the overall total pass percentages, then in 2019, it seems like we had a 46.40, so let's say 46.5% more or less. Whereas in March 2020, we had a 64. So there's almost what's that? It's about an 18% difference there. Improvement in March. And then, of course, we had the fall in the November one to 34. So it's down with another 30%. And then we went up with 30% or just under 30% in March of this year. If we look at that Excel spreadsheet. And so I have another question. I have a question and say, what was the reason? I don't want to look at it just negatively. So I'm saying, what was the reason for the change of the pass rate from, thanks, there's the spreadsheet up. So you can see I was quoting from the right-hand column, the total, which moves down from the top down. It was 2019, beginning 2020, then November 2020, and then the bottom one, the 61.10% or 0.1% was then this year, March. My question is, what was the reason for the good increase in between August 2019 and March 2020, and then again between November and March this year? Because, you know, my question is that a matter of luck, or is that certain things that were done? Is there certain things, certain ways that we've changed? So I think those are important questions as well. But just speaking for the November, about the November question, I think that, you know, I hear it's been dealt with, and you know, I've been included in the discussion regarding that took place on the 19th of this month. But I'm not sure that we really have dealt with that paper 3. I'm not sure where exactly that was finally dealt with. To me, there's questions raised about that paper, and maybe if we can, with the meetings permission, have a look at that at some stage. We need to ask questions, because I'm careful to just assume that it's got to do with COVID, and that's the only reason. So I wouldn't want us to just step away from that. Plus, I think at the 19th meeting, there were just drafters involved, or if I'm correct, maybe Tony them can help me. Whereas now we've got a team of presenters, people from practice. And so maybe we should just raise that. And then I've got one more general point, and then we can, then I'll first stop speaking. But the other general point I've got is that this is a very large group we've got here, and it's a brilliant way to kick off, I think. So well done for that. But I do think that we are in various subject areas involved. So one should perhaps at some stage, if we drill down, because, you know, my feeling is what you can measure, you can manage, is we should have each of the individual areas have have a closer look at all the various aspects. In other words, match court practice, high court practice, personal injury claims, and criminal law. If you look at paper 1, for example, I won't be able to give much input into the attorney's bookkeeping, but Mr. de Kock and company will be able to do that. So that's maybe their expert areas. And so whilst I'm not saying that we would be lost on I mean, we're all practitioners and we all have attorneys, bookkeeping and so on. I think it's important in future that we also look at it a little bit more from a special subject area point of view and really drill down and see. If I can just express my thing as a presenter, if I know that people are doing bad in an exam because of in an area, let's say in match court practice where I'm involved in, so as far as lecturing is concerned, and I realize they're doing bad on a question on drafting particulars of claim or on absolution of the instance as an example, and I know from my area there's a problem, then I'm not saying that the lecturer takes the full blame, because as you well pointed out, there's a lot of factors that plays a part in it. But I would like to know if there's a problem so that we can address that and provide better input and maybe allocate more time. I mean, we are in the process of much less exposure time that the candidate attorneys have to the presentations. We've been cut in all areas. And so we need ways and means of getting a more effective use of that time. And so, yes, so there's just a couple of general points. I think that if I can summarize the 3 things there, the first thing is I think we need to have this sort of exercise to go ahead. I think we need to look in detail at where things improved as well, and then at those outlying aspects where we maybe did a little bit worse. And then thirdly, that we drill down in subject areas as well at some stage so that we can understand the various participants where they are. I mean, we're all experts in our areas, but we can also learn a lot from one another and so on. Thanks, Chris. Appreciate it.
Thank you very much, Etienne. I think you preempted 1 or 2 matters, which are, it's good that you raise it now. As we pointed out, this is a very broad-based group, a collective, and the idea of this webinar was to take in a broad overview and participation without going into too narrow specificities, you know, and also, as you use the word, drilling down into specifics and specialist areas at this stage. But you correctly pointed out that there are going to be discussions that may require us to deal with subjects specifically or other topics that deal with PBT issues. So one of the intentions, and I think Ogilvy would have spoken about this at the end, is that there will be further webinars touching on those very points that you raised, Etienne. And it also will underline some of the things that Henry has also raised. In other words, ensuring that best practices and better practices are cemented and advanced. And moving forward, that the webinars that might arise again and will take place will take into account all those kinds of matters. So you might find you would be invited to a webinar possibly on issues surrounding, say, paper 1, or maybe a particular subject where there were problems. It may be just, say, ethics or criminal procedure, whatever it is. That's the point that I wanted to underline, and it reinforces what you just said, Etienne. The other issue about the reason for the glitch that we had in November, I think there are many of us on this who could speak to it and how it was in some way identified, and further how it was overcome with better systems and so on. And I'm sure Tony and Ogilvy can speak to that, but it's an important point just to cover as well. I know Andre has got his hand up, but at any point, if people want to also address the questions that Etienne raised, at whichever point, we will cover it. So please feel free to raise your hand, and I will, if not, I may ask some or other member on this webinar to speak to that particular November 2020 matter. So I will first deal with Andre, and I also recognize Henry's hands as well. So Andre, you go first. Thank you.
Thank you very much. In the November, the one question I want to ask is, when we're doing these statistics, I see the did not write are included in the total. Now, if a person didn't write, why are we including him in the total? He shouldn't be there. He didn't write, so he neither passed nor failed. So he wasn't part of, he didn't write the exam. So I don't think firstly, those should be part of the total in the calculation. The second thing is, I'm not too sure, what does oral mean? Does oral mean, and if you have a look in here, we've got 2,617 oral. Now, are those oral passes? Are they fails, or what are they? And are these 2,617 part of the 4.3? What is the 2,617 exactly? Because if those orals are all oral passes, add them to the passes, then our pass rate in November is 56%. And if you have a look in the other exams, the orals are nowhere near to 2,600. There are only 216. And we've got 200, well, in August 19 we haven't got, and 378. But in the November, there's a huge amount of orals, but I don't know if they are people who have passed or what, maybe, because what I'm saying, we're looking at the statistics, but we need to look carefully at the statistics, because are those passes or are they not? What can somebody help what they are? Ogilvy, maybe you know, I'm not too sure.
Thank you, Andre, for that question. Let's just park those two questions that are very, very important. I just want to take Henry first, and then I'll turn to Ogilvy to give him a chance while we take Henry to come up with an answer. And I'm sure Tony as well might be able to assist. But Henry, you've got the floor. Unless, Henry, it's an old hand, or are you muted still?
Yes, I'm sorry about that.
No,
the old
ahead.
mistake creeps in yet again. Sorry about that. Thanks, Krish. Etienne posed the question earlier on, I think it was Etienne. He wondered why there was then an increase in the pass rate, the overall pass rate, since the November 2020 or so. I have no doubt about it that we at NADEL introduced the refresher course or courses that we run just before the exams are written in all the subjects, all 4 papers, and it is countrywide. And I think it is paying off dividends at the moment with the increase in the pass rate. Thank you.
Thank you very much, Henry. I want to, before I go to Ogilvy or the management, just to get Emil. I see Emil's hand is up, and please put your hand down, drop it once you're over, so we can see who's in, who wishes to speak and so on. So Emil, you have the floor. Thank you.
Right, yes, thank you. I think I need to talk about this astounding figure of 12% in the November exam for paper 3, which we all call ethics, but in fact ethics is no more than 20% of it. The reason for that pass rate is fairly obvious. I've been drafting these papers for 30 years, and I can assure you the standard was no better, lower or higher than it's been for 30 years. The difference was the following. We received a very specific instruction that in drafting papers for that exam, we should not repeat previous questions. That was a specific instruction. And we all know, or I certainly know, that on paper 3, preparation is done by working through old papers. The fields that they're examined on are extensive. It's company law, it's trusts, it's partnerships, it's drafting of contracts, it's marital law, it's professional conduct. It's a very wide field, and the only way the students find it easy to prepare is simply to do old papers. Now that's fine, provided that's not the only thing you do. But I'm afraid that's what's been developing, is that they don't go through the work, they do the actual old papers, and that's all they do. And if there is not a single question that has been previously asked, as we were instructed to do, the result is a foregone conclusion. So it didn't surprise me, really. We tried to adapt in the subsequent papers to be a little bit more sympathetic by repeating not questions, but certainly topics. And in passing, I might refer to the question of the business rescue, which seems to have been something that upset various people. Now, I have to tell you that the whole question on business rescue came verbatim from the manual on insolvency. It's there verbatim, and not only in the insolvency paper, it's also in the company law manual. Now, the reason nobody was able to do it is because it's only been asked once before, and in a very short form. So I must say I'm terribly sorry for the candidates, but it really was no more difficult than anything else that had been asked before. And that's the explanation on that one, for what it's worth. I've tried to revert to what I used to do before without repeating questions, and it seems the results are a bit better. But I thought I'd just explain that one, because it was the one result that stuck out like a sore thumb, wasn't it? Thank you.
Yes, thank you very much for that input, Emil. I'm sure we will try to address this issue of how does one take directions, and what is the test? Is it about trying to trap candidates, or to, in other words, the word ambush has been used. That certainly would not have been your intention, Emil, but we want to see candidate legal practitioners being able to pass exams in a fair manner and to practice. And if business rescue is an important aspect and the question is relevant, we must find ways in which we say that, look, your next examination, please be alert. We are going to go beyond the norms. We might be focusing on matters from your insolvency manual or some other set of we'll call it lecture notes, etc. But it's just a thought. I'm going to recognize first Tony and then Etienne. Tony, you go first.
Thank you, Mr. Chair. I think Emil did allude to the 12%. If you take that 20% of that exam, and if you remove the question on business rescue, 37% of the candidates failed the other subjects, the other matters covered in that paper. So that's the first thing that I wanted members to note, that it's not only that question that caused them to fail. 37% would have failed if we remove that question altogether. Then the second thing, Mr. Chair, is the question that Andre raised on the orals. Orals at I'm a bit embarrassed to say that that was the interim results that we shared at the LSSA. At the time we shared those results, the orals weren't completed. So orals are basically candidates who, in certain subjects, achieve between 40 and 50. They're then entitled to come and do an oral exam. And I know it improved slightly the marks overall, but I think it was about 15% impacted on the actual pass rate across the board from those orals, Andre. So candidates do come in, and I'm explaining why there is an oral, but those results, they haven't been properly calculated. With regards to the did not write, when I did the calculations for the LSSA, I removed those did not write and changed the percentages and totals because they should not, in the LPC stats, they actually are included, and I did flag that to the LPC sometime back and again recently. The other problems that we have with the exams is that we have not yet got the final results from the LPC despite requesting it, and therefore we couldn't even drill down into regional differences which we can look at. So those are some of the things that I wanted to raise, Mr. Chair, that those are challenges that we have. We cannot also, Andre asked me previously to check if we can track candidates because of the POPI requirements and privacy, even long before POPI. The LPC correctly does not give us the results per candidate, per name, so that we can track them, or per ID number. So it's very difficult for us to track the actual candidates who move, and if we can get that maybe in the future, it will be good. And then to come back to what Emile talked about, the instruction, the chair of this meeting is aware that we had ongoing discussions with the LPC's Education Committee. And when we looked at the past questions, we did analysis, and I'm embarrassed to say that over 30% of the questions in the past 8 years, when we analyzed, were repeats of the previous questions with slight subtle differences. And Emile, that's why Emile said to you that that there was a request to change. Over 30% of all exam questions across, on average, were repeated in the last 8 years admission exams. And Krish is a member of that education committee, and you will know that we were embarrassed as the LSSA that we never did that exercise previously, but we did it at the request of the LPC. So those are some of the challenges that we faced. Etienne raised the question, the last meeting we had was only of drafters, and the drafters at the meeting, we were preparing for the examinations that are coming up in August. I'm not sure if they will continue in August. There is an LPC meeting scheduled for Friday, and one of the things that I've written to the LPC is to consider postponing that exams because of the uncertainty of venues. But at the meeting that we had with the LPC, the examiners, the drafters, let me be specific, the drafters looked at the questions and agreed that the examination questions that has been changed since the last 2 exams. One, that the questions themselves will not be complicated because it's not there to confuse the candidates, it's to test their knowledge of the applicability of practice. That was the first thing that was identified by the drafters. The second thing that was identified by the drafters of the exams is that the integrity of the exams must not lead the profession to be questioned about its ability, its performance, its benchmarks, and its integrity. That was the second thing that the drafters agreed. And then the third and very important thing, it has got 2 components that the drafters agreed, that admissions exams and practical exams must be directly related to practice. It must be relevant to practice, and the standard must be of a level that allows the public to be comfortable that the practitioner who comes through has the requisite level of competency. And it's not to put the competency as somebody who's practiced for 20 years, but to have the requisite level of competence. So I just thought, Mr. Chair, I would just raise those issues so to get the background clear with everybody. Thank you, Mr. Chair.
Thank you very much for that, Tony. And just a small question, Tony. Is it not preferable that we remove the did not write when we do all these stats and put it, somewhere else with a little asterisk just to say X number did not write? But
Mr. Chair, sorry, it's correct. It should not even reflect. That's an administrative thing that the LPC, we have pointed it out to the ICT people, and Jeff was going to remove it. But I think when Ogilvy copied, he copied those things exactly as they came. But when I do the stats for the LSSA and the SELE, I remove that did not write because it adds nothing to the results and actually distorts the percentages because currently, in terms of the system on the LPC, it automatically calculates a percentage of the total. So it distorts the actual total. So it should actually disappear altogether.
Well, I'm sure Melissa is listening too, and I'm sure this will work. There would be some way in which that can be dealt with, and I'm very pleased that this matter was actually picked up now by Andre, and we are in a position to understand the stats a little clearer. But thanks for that other inputs that you gave, Tony. I'm sure they go some way towards understanding the challenges that we still have and the way forward. I am going to turn back to Etienne and then Chris after Etienne. Etienne, you going first.
Thank you, Christian. Thanks. All right, I want to make a comment in respect of the business rescue question, and it's related to what Tony has now raised as the third identified criteria. And it's really not to step on toes or to try and take an opposite position, but when we say the admission exams must be practice orientated, now we must understand the relationship between the practice manuals of the LSSA and practice and the admission exam. The first thing is that the practice manuals of necessity must delve in matters of maybe more theory as well, to give background and to give the legal content to something like, for example, business rescue. When one goes into a good theory preparer or a good teacher, I think, would teach more difficult than even is required for the exams because you're thinking practice orientated. But then when we think about who our audience is or the consumer of the examinations, then it's the candidate attorneys. Now, I want to ask of all the practitioners that are in our audience today, you mentioned something like 40. How many of us deal regularly with business rescue? Now I want to take it one step further and say we're expecting a very junior attorney. That's what the exam level is at, so or at a reasonably qualified junior attorney. That would be someone that goes and writes the admission exams. Let's say a candidate attorney after the articles period or in the articles period. If there are very few of us that do business rescue, and I mean we can do that count if we want, then I can assure you that amongst candidate attorneys, there's going to be extremely little that deal with it throughout the country. So of your 6,000 candidate attorneys, maybe there's a select few hundred, as Dr. Laram referred to earlier, that somewhere along the line is in a large firm or they're dealing with this. But, and I'm not saying don't ask business rescue, but maybe we should look at the method we introduced new material. For example, the November 22 exam had 22 marks on business rescue. Now, if it's the first time or one of the first times this topic is questioned or asked, I agree with the point that one should perhaps give a forewarning to people to say prepare on insolvency or in detail or whatever. But the other thing that I think, if you don't do that, is at least introduce it in small bite-sized pieces. Someone that out of a paper that is 100 marks and you suddenly get bold on 22 marks, it might be skewing the result of the caliber of people that we get in. Someone might have made a mistake there. And so I think that a 22-mark question on a topic that is really, and I'm going to put it in elite, in inverted commas, maybe more of an elite practice area, or not elite, it's a bad word, maybe more of really a few people that practice in that. I'm not sure that is the way we should go. So I would think that we should have some more other guidelines as to how and when we introduce new material. I think that's one thing. And then secondly, also the length of questions. I think that's important. And I say once again, I'm not critical, having drafted many of these exams, or tried to draft many of these for the schools and for being part of the match court practice panel for the drafters at the admission exams. The experience is occasionally you need to ask a long question, but you must be sure that this is an area that is expected. I mean, if it's a question on particulars of claim, I would expect the 22 marks. But to go and take 22 marks on something like so I might have a different view, and I apologize for raising that again. I didn't raise in the 19th because I couldn't attend the meeting. Unfortunately, I wanted to. But I think it's important, yeah, amongst this group also, so that we can just touch bases and say, how do we introduce new material, and if we do that, when do we do it? Do we do it the next month? If the law changed last month, I think that's not fair. If we do it the next year or the next 2 years, what would be a fair approach in that? Thanks.
Thank you very much, Etienne. I think those points will have to be just noted and taken into account. And if at the end of it, we come up with a process going forward, these are the kind of questions that we would have to work through and address. But it doesn't prevent people from coming up with further inputs. Before I turn to Chris, I just want to read a message that on our chat that had come through from, there have been 1 or 2 comments that have been made, which I think I won't, Donovan asked that we should look at results for about 2 years before the onset of COVID to get an idea of the impact that COVID has had on the results. I think that's an important point. And Tony made comments concerning the new norms and standards that have been published by the LPC, which would have impacted on the outcomes and areas of focus. And then there was a question that Henry had asked that Breitenbach had asked him to articulate 3 problem areas, raise experience at schools, namely eloquency and language in answering questions, lack of discretion in awarding an overall mark when assessing answers in the exams, and the lack of participation during lectures. Tony has also mentioned exam preparation classes have been done by BLA and Legal Education Center for many years, and there's training is open, and
in Sandbar on the motor.
And PVT schools are also part of the training program.
Yeah.
I think someone's got the microphone on, so please bear with us and mute yourself. Those were just some of the comments. I think Arthur van Coller had a question on stats and so on, but if you put up your hand, Arthur, I'll come to you. But
it is up, yeah, it is up.
Okay.
I don't know if you can see it.
Yeah, I can, but I'll take Chris first, and then I'll come back to you, Arthur. So Chris, you have the floor. Thank you.
Thanks, Krish. Just a more holistic comment to move away from the specifics for the moment. I ask myself, what is the end objective of our law schools and our legal education? And then the question arises, are we preparing our candidates to pass the exams? Or are we preparing our candidates to solve their clients' problems? And for me, this is terribly important, because the exam to me is only a step towards the attainment of the final product of being able to let loose on the public people who are able to solve their problems. Now, I come from an era where we had no law schools, we had no syllabuses. You were asked anything under the sun that the examiners could think of. There was nothing whatsoever. And I'm rather apprehensive and nervous when people say to candidates, you need not study this, it hasn't been asked the last 5 years, unlikely to be asked again. That makes me nervous, because we are then saying to the students, you can limit your studies. I'm of the opinion that we should not allow them to limit their studies. They should be told there is a syllabus. The syllabus is covered by the study guide. The syllabus should be covered by the lecturers, and they shouldn't be taken by surprise by past history and so on. A further point is that I believe that the moot courts are not sufficient in the following sense of the word. We have one moot court for civil, for match court, and one moot court for high court. I think with respect, that's insufficient. What one finds in practice is that, let's say, for example, they do the match court first. They don't fare so well. They do it the second time with the high court. 2 weeks later, there's an improvement. But still not of a standard which I would believe will then really, in practice, suffice to then conduct a real trial, especially in regard to the cross-examinations. I would also suggest that we consider simulated consultations. For example, you have a situation where the lecturer or 2 lecturers go into a firm and say, right, without any preparation by the firm, here are my problems. My problem is A, B, and C. And let them off the cuff, as you get in practice, you have to then solve the client's problem and see how they fare. Of course, at that stage of the proceedings, they should have sufficient legal knowledge, theoretically and in practice, to at least give the client a basic advice. And if they could have 1 or 2 of those simulated consultations where they off the cuff have to look at the client's legal situation, commercial considerations, and give the client some type of advice, I think this would enhance the end objective of how we clothe our candidates. Thanks, Krish.
Thank you very much, Chris. I think you raised some very important points that I hope also that our school principals and others who are in the PLT schools who are on this webinar, that they could even give us some responses and be part of this process, because you are at the coalface, and your experiences and ideas too will help, and the suggestions coming from the participants now are also important to deal with. So let me turn to Arthur then. You have the floor, Arthur.
Thank you. Yeah, my question, I sometimes get confused with stats because they sometimes don't show the real picture, and I was wondering what else you track, specifically relating to individual student performance. If one looks at March 21 in paper 1, 52% of students passed as opposed to 47% the previous one. But do you also track the individual student performance? And I'll tell you why. We just looked at the extended LLB, and the performance of the average of stayed the same. But when we started looking at individual performance, it dramatically reduced. So initially some students were getting in the 80s, some were getting in 70s, 60s, but as we go along, the pass rate remained the same, but now the students are all in the 50s. So the average student performance has decreased dramatically. The other question relating to stats is, one of your questions that you will ask later is, does the school prepare the students for the admission exam? The question is, do you track the students that have gone to the schools separately from the students that don't, or the candidates, so that one could see if their performance is substantially different because they attended school? So I'm just wondering if there are more stats available to give us a better picture of what we are doing, because sometimes stats hide things that we might want to see. Thank you.
Okay, thank you very much, Arthur. I'm going to just keep the discussion moving, and if members on this webinar want to answer specific questions or contribute, please. We are, in my view, collating all these questions too, and we'll find a process through LEAD and Ogilvy's team to probably by addressing these questions through the schools, etc., you might come back with some feedback or whatever that we can share. But it doesn't stop us from dealing with it now. We do have about an hour left. So what I'd like to do is ask Ogilvy to, if it's okay, I think we should run through the rest of the questions that's on the list, that's on your screen. And maybe we can move the sheet a bit up so that we can catch the remainder of the questions. So what I would like to ask is that we also address the bullet points that are there right to the end in a collective way, so that we don't have to be restricted. Some of these things, or these bullet points, may not have been touched on at all, and some may have. In other words, like drafting, can the drafters ensure that questions are at an acceptable standard, and how can we ensure that teaching, instruction and exams are relevant? These are important questions, but there are other matters like the quality of lecturing. Does attending PVT courses and or schools assist with the preparation of the candidates for practice? That question has come up just now, where I think it was Arthur who said those days we didn't have all the luxury or benefits, if I have to put it better, of what we have now. But still, these are important matters, and I'm sure PVT is a very important process. So I'm going to invite further comments, but if there's any input from any of the school principals and anyone else, I see one hand has been raised. It's gone down. Okay, it was too fast for me. Or two people have raised their hands. Let me identify them. Henry is first, and let me see the other person. Well, okay, Henry, you have the floor, as I can only see one hand at the moment. Thank you.
Thank you very much for the opportunity. I think that one's approach as a lecturer should be in preparing the candidates for practice and not only for the examinations. And having said that, I think that as a lecturer then, or facilitator, one should think out of the box and look at the climate in South Africa at the moment and deal with those issues in anticipation that a examiner who sets the papers may identify something like that. But I think that Chris made a very interesting point, and a good point early on. I think that first and foremost, before one even starts with the guide, one has to revisit the syllabus by LEAD and look at the areas. Certain areas have been cordoned off now where you're guided by legislation, but not only the whole of the legislation, but also specific sections that you must emphasize with the candidates. That is my contribution.
Thank you very much, Henry. I think, TT, it's you who have your hand up as well. You have the floor.
Thanks, Chairperson, and good afternoon, colleagues. My comment briefly is on the stats provided. The manner in which the stats have been drafted makes it a little complicated for somebody to comment on issues such as the quality of instruction or lecturing. This is because we do not know whether stats were done in respect of the different provinces, or it's just a general calculation, it's a national figure given. For example, you may find that although there is a problem with performance generally, but another province is not necessarily affected. You find that, for instance, from the number of people who wrote in the Free State, you have 80% pass rate. And from those who wrote in Mpumalanga, you have 75% of people who passed. And because we are using a national figure, we end up having the whole percentage somewhere down. And because of these, it becomes very difficult to say if there is an improvement to be made. How do you improve if you do not know how your performance was? If, say, I am in the Cape, and in the Cape, there is 90% performance, and there is speech about bad performance. How do I tell? When I look at my own stats, I see that the performance is not as bad as is said. The reason that it is said to be bad is because we are looking at it generally. Another thing is, we seem to be focusing more on the schools, whereas the admission exams are not only written by people who come from the schools or who did PVT at the schools for legal practice. You also have people who simply have an LLB and articles. They did not attend law school at all, and they write these examinations. In most of the instances, when you mark the papers, you are able to tell the difference between somebody who did PVT at the law school and somebody who did not at all. You will also see by the manner in which they are answering, more especially when you mark paper 4, you will see that this person has no clue at all. So to a higher extent, the attendance at school for legal practice plays an important role and does assist in preparing candidates for the admission examination. So in a nutshell, Chairperson, if these stats were broken down further to also deal with provincial states, I think we would be able to make a meaningful contribution. Thank you.
Well, thank you very much, TT. I think you've raised something that's very important, and I must say, I hope we can get some clarity on those, because the point that you made, TT, is about the fact that there are people or candidates who are writing exams that have not gone through the schools, etc. Now, that is something we must try to understand in relation to the product that LEAD is marketing, and which is there for candidate legal practitioners to turn to use. And I want to make this point in passing, but it's important to underline it somewhere, that in terms of the Legal Practice Act, there are now many groups, individuals who are opening colleges for PVT training. And these are being subjected to scrutiny and accreditation through the legal practice councils, committees. And there are some who are bent on making money at the expense of training. And when we've seen some of the fees that they are charging, it's quite interesting. And you look at what capabilities they have of training, that's also questionable. Then there are also one or two small firms that want to, on the side, do training for profit. Now, we are dealing with all types of matters in a very competitive environment, and in terms of our economic situation in the country, where competition is part of our law, and one must be able to open up all forms of business enterprises to whoever is able to provide it. Accrediting training institution is becoming quite a testing process and challenging. And therefore, the point that TT has raised is that if we want to market the schools and lead in a competitive environment, which they're now in, and which they weren't in before the Legal Practice Act came into force, it means that you have to look at your percentages now carefully. You need to identify through each school, and I must say it might help to identify the best performing schools as well, and take best practices from those particular schools so that there's uniformity as well. So all of these things are part of the branding, part of advertising your good product, and also in a way publishing the good outcomes as part of advertising and saying how successful you are in your particular venture. So I'm not sure, and I hope Tony and others might give clarity on the questions raised. But before I turn to Tony and anybody else, let me first recognize Jodine. You have the floor, Jodine. Thank you.
Good afternoon. Thank you very much for the opportunity. I actually want to tie in with what Titi said with regards to the quality of the lecturing and improving on that. For me, I mean, I haven't been involved for that many years in preparing candidate legal practitioners for their exams. And I think I've been doing it for 3 or 4 years only now. But in my short space of experience that I have found, I would have appreciated as a lecturer some feedback on the quality of my lecturing. I know that there's an evaluation form that's completed at the end of the lectures by the students or the candidate legal practitioners. And I think if one can, as a lecturer, receive feedback from that, so one can see as an individual whether there's something you can improve on, maybe using more overhead projectors or tools or anything like that. If you can get feedback from the students on how you as an individual can perhaps improve their comprehension of the subject that you're lecturing, it would also assist. I mean, just in this short space that I've been involved in this, I've gone from lecturing in group form to lecturing virtually, which I think also has a great impact. So I just wanted to tie in with that because it ties in with that questions on whether the lecturers were different from previous years to what they are now, as opposed to, or in addition to, can the quality of the lecturing be improved? I think we can only address that if we know whether we actually have any criticism that was given by the students on aspects of how we as an individual lectured. That's all I wanted to contribute. Thank you very much.
Before you step off, Jodine, do you not get to see the responses of the candidate legal practitioners to the questionnaire that you circulate?
I don't know. I don't know if the others do, but I never get any feedback whatsoever.
Yeah, well, that defeats the purpose then, really, of having
I
that.
assumed it was more for the management of LEAD itself, but I would have appreciated some feedback. It would help.
Yes, I think we must encourage that, and I think it seems to be that is the norm. So let's try and look at it. But Tony, I recognize you, please. Maybe you'll address it, but thank you, Jody.
Sorry,
Tony,
Mr.
you're
Chair.
muted.
Yeah,
Okay, right.
I'd like to respond to Jodine. The purpose of that evaluation is to evaluate the instructor, and it should be shared because every year the instructors panel list with the evaluation goes through to the school's advisory committee for reporting. So I'm not sure, but I will contact you offline and make sure, and I'll also speak to the rest of the schools to ensure that they are following that process, because we have meetings twice a year, and at each meeting the assessment of instructors and their responses as well, the instructors' responses are tabled. So definitely I'll get back to you. Mr. Chair, I've been posting comments on some of the questions, so I won't go into them in depth, but I'd like to say that with regards to the in-depth analysis, as TT correctly pointed out, and I think we did discuss it at the beginning, I think there would be benefit for us to do proper analysis of those stats and the stats to be properly prepared, and have a follow-up webinar where we can take all the questions, because there's so much input that's been made. We won't do justice to finish it by 4 o'clock, Mr. Chair. So I just got the two general comments.
Yeah, Chair, I'm sorry, Tony, please make sure that all the questions that emanated from this webinar are collated in some form, so that we can commit to some sort of future webinar where all the questions can be tabled and with some answers, and then it would allow for some discussion. But that's just one of the steps on the way forward. But thank you for that, Tony. I also wanted to say that there are questions and comments in the chat section there, which are important, and I've seen some comments from Farhana and about the paper one having this tiny section on criminal law for 2 marks.
Yeah.
And that,
I'm laughing, Mr. Chair. I've already posted that question to the drafters of that paper.
Yeah, so it's quite important. These are all things that we need to note. Criminal law is a major part of practice and our life in the country and so on. So I'm just parking that on the side. I'm going to take the next two persons who have their hands up in the following order. First, Arthur van Coller, and then Etienne Barnard. So Arthur, you can go first.
Thank you. I just want to comment on the quality of lecturing and the teaching to be relevant to the demands of practice. And it's maybe just because I'm in the Eastern Cape and we can't really travel as much as we used to. So sometimes we feel a bit isolated. While we're lecturing, we get really good questions from our students and we make notes. And sometimes we see issues in the learning material, and I'm specifically talking about the schools now, where we would like to have some input to the drafters. And it's not always that easy to have a line of communication to get those comments across. So I was wondering if it can be made a bit easier for us to, after we've lectured, maybe get together in that, all the lecturers that were done on a Zoom meeting or this platform, just to give comments and feedback as to how the material can be improved and the experiences that we had, because that I think would improve the lecturing material a lot, and also assist with the lecturing if we can just have a quick conversation. So that's my comment. Thank you so much.
Oh, thank you very much, Arthur. I'm sure that will also be noted. I'll take Etienne next. Etienne, you have the floor.
Thank you, Krish. Yes, I agree with that previous comment. If we can touch bases with one another, we do certainly improve the way forward. But my hand is raised in respect of a comment. I'm just concerned that we sow a bit of confusion about our role. So Tony just made a comment on the difference between the schools and the PVT, saying that the schools prepare candidates for practice on the 150-hour PVT short course or for candidates in PVT contract, and is largely focused on exam preparation. Now, that I don't think is a true statement of what the Legal Practice Act requires of us. Practical vocational training, by its very definition, is a training of a candidate with skills and knowledge to be able to perform in practice. So I don't think we should propound that purpose of the course. Our purpose was and is always in that short course to train the candidate attorneys for practice. I almost want to say the exam preparation is in brackets, secondary maybe function of that, but if we do our job properly, it will be seriously canvassed. I do not think we should advocate that the practice vocational training is actually an exam prep course. I understand that there's later in the year there are courses like the one referred to by Nadel or the BLA, I think Tony referred to earlier as well in the comments. I understand that those are there for exam prep specifically, and I agree that even the LSSA had those. I can remember back in the day that for candidate attorneys from our offices also attended that. So certainly that we mustn't sow confusion. We are not there to teach people how to pass exams. We are there to teach them how to perform in practice at a reasonable level. The practice exam is there to test whether they can perform at that level, and maybe that's where the bases touch. But I'm very concerned that we reduce, because of the time pressures and budget, that we reduce what the Act says is a vocational training to an exam prep.
Okay, thank you, Etienne. I think before I turn to Frans, I just want to point out that a lot of the training that is done by Nadel and BLA is not specifically focused on the exams. There are certain lectures that I held by Nadel, I know as far as Nadel is concerned, specifically before the exams on the papers, but that's a separate assistance and support to those who take up the offer. It's merely an offer, and I know some of our attorneys do sterling work, giving up Saturdays and Sundays to do the training just before the exam, but that's quite different. There are lots of seminars and symposia that has been held by Nadel and BLA that have everything to do with practice and maybe not so much to do with the actual exam. For example, medical negligence. I know Nadel runs these courses, training courses, and I'm not sure, if I'm not mistaken, I think Henry also might have lectured on those topics, but it's done from a practice point of view, assisting young practitioners as to how to go about dealing with expert evidence, dealing with formulating particulars, presenting the case in every practical sense of the word, which benefits any legal firm. Similarly, with constitutional law and constitutional principles, we've had, I think, a judge of the Constitutional Court run these lectures around the country and did a fantastic job of breaking down all these complex issues and principles. So it's a fairly broad thing. Your point is well made, Etienne. I think it's a matter of looking at content and how they, and the outcomes that they hope to achieve. And I think everybody is committed to having a candidate legal practitioner be as best as possible prepared to be able to set up a practice and run a practice and do law and practice law, and not think that the examination was the be-all and end-all of their development. So I think this is why LEAD also runs those many other courses through their professional support lecture series. So I'll just stop there and I'll give you the floor, Franz. It's all yours. Thank you.
Thank you, Chair. Adding on to what Titi and various other people have said about the stats and the fact that we can't really distinguish between those who've attended PLT and those not, I think the one common factor there is that most, if not all, of the candidates use the study material, the practice manuals, as we call them, and therefore it is very important that those manuals be correct and be updated. Now, I know they're being updated, but I get the idea, specifically in High Court practice, that drafters simply add new material instead of really revising material and looking at previous things. I want to give you one example. In the High Court practice manual, page 36, for those who want to go and check, it is stated categorically that at present, the Mora interest rate is 10.5%. Now, that was the position last in August 2017. So in all these years, nobody's picked up amongst the drafters because they just add stuff. They don't really go back to the existing stuff, it seems to me. Okay, now at the PLT school, the lecturer will point out that this is no longer the case and the present rate is 7% or whatever it may be at that stage. But those not attending school, they're also studying from this material. And I can tell you various other examples, simply mistakes, simply wrong stuff in the material. Although I must grant that it has improved in the past 2-3 years a lot, but there are certain precedents that are simply outdated. They do not even take the National Credit Act into account when drafting particulars of claim, for instance, on a credit agreement. So yeah, I think that requires serious attention. And I know it's easier said than done. It's the same with the hours allocated. Within the constraints of budgets, hours are cut, not extended. Fees of lecturers are cut, not increased. And that's the reality. But I think the priority should be the study material. That's the one common denominator that all candidates writing the exam have. Thank you, Chair.
Thank you very much, Franz. I think all of these matters, even if it's easier said than done, let's say it so that we can scrutinize and interrogate these issues. I do note that there are two persons I identified on our group. We approximately 35 or so, but there's Chandika and Desiree who are from the schools. I don't want to put you on the spot, but I do think that a lot has come out. There are a lot of questions too on this webinar list that we put up on the screen. And if there's some broad overview or even any specific answers you can give us, I'd like to invite you. We have about 15 odd minutes or 20 minutes left. And I don't want to lose that opportunity of allowing those who are at the coalface to also give us their views on some of the comments and questions and also on their experiences. So let me invite Desiree first, please, if you don't mind.
Thank you so much, Krish, for giving me the opportunity. Yeah, just from my experience at the Port Elizabeth School, I'm so sorry for the noise in the background, but there's grass being cut, so I'm very sorry about that.
As long as it's not gunshot.
So one of the issues that we've had to deal with, obviously, is the amount of time that has been devoted to the different subjects. Henry, who is an instructor at my school, spoke very eloquently about the fact that in regard to the ethics paper, or the ethics course, that the time has been slashed right down to the bone. In my conversations with my instructors, that has been an issue, the fact that there is limited contact time, or the contact time has been shortened considerably with the cuts that have been made in the program, and so on. And we've also then had to contend with the online situation that we've been forced into. My experience at my school is that it's working very well for some of the instructors. In the meeting that I had about a month ago, some of my instructors were very, very positive of the about the online platform and were quite comfortable using it. I think Mike Fenter is on this meeting as well. He reported that there was a lot of interaction with the students even using the online platform. Then we have the situation with some of the instructors who are not familiar and very uncomfortable with that. I teach in the law faculty as well, and this is a problem that we all have, where students are not necessarily as engaged using the online platform as they would be in a contact kind of session, or in a classroom kind of setting. And that's the reality of that. And at my school, what I'm trying to do is to arrange for training for my instructors who need it, using the blended model, blended learning model, to try and make instructors more comfortable with that particular platform, as there is a lot of online content, both with the schools and with the courses. And so obviously we are trying, and I believe it's imperative that we take steps to accommodate the changed circumstances that we find ourselves in, which necessitates using the different or the online platform to present the content to the students. The manuals that are being updated, I must admit that some of my instructors have noted their concerns, as were pointed out, with the fact that certain things are outdated. My instructor in insolvency basically has communicated with me about the fact that the insolvency manual, for example, needs a huge overhaul with regard to the fact that there is a business rescue, and she points out, just in a conversation that I had with her a little while ago, that with the present state of the country, the economy, and so on, business rescue is becoming so much more common. And so that obviously our materials need to take into consideration the changing circumstances, as well as keeping up to date with the changes in the law itself. So yeah, just from my side, I just wanted to say that I take on board the comments that have been made in the discussions we've had and today, and just want to say that this, well, for us in Port Elizabeth, these are issues that we identify with, and obviously are encountering it just as the principal from my personal experience. Yeah, this is something that we've been seeing as well. Thank you, Krish, for the opportunity.
No, thank you very much for that, Desiree. I'm sure all of us would have benefited from hearing your direct concerns about how you have to cope with changed circumstances. I think you may have just briefly touched on budgets and its impact. I think it needs greater comment from other people, but may not be useful to deal with it now, because when the LPC slashed the budgets of LEAD, I mean, there definitely would be adverse consequences like what we are hearing. So all the points that you've raised, training of tutors in online training methods and all the other things that go with it are all very, very crucial. So thank you for that. And we'll follow up, and I'm sure your comments will be also picked up as part of the ongoing process that we hope to have going forward. And I'll ask Chandika, please, to add and comment further if you can.
Thank you, Krish. I have some of my instructors who are part of this meeting, and one of my oldest instructors, not just literally but figuratively, is Chris Duplessis, and he's been very passionate about legal education. I'm just going to highlight some of the questions, try to answer some of the questions that were posed. Was lecturing last year different from previous years? Yes, very much so. We had to get instructors to record lectures, and these were posted for students on our eLeader platform. As a result, you know, they had less contact on some of the subjects that were presented as previous years. I'm not sure whether that contributed to the bad results last year. But we tried, you know, to assist students as far as possible, especially during the lockdown period. What does assist students with regard to preparing for the admission exams? The program at the schools at that level, we prepare students predominantly for practice. So there's a lot of simulation that takes place. For example, we start them off with opening up a practice, for example. We do a simulation, we break them up into firm groups. And, you know, how do they go about establishing a firm? And in each course, obviously, besides the lecture, students get in-house, well, assignments on drafting. So that happens to assist them further. And sorry, I'm just talking about what happens in the Johannesburg school. So they do that besides what we have already available on our eLeader platform. But the aim of the course at the schools is predominantly to prepare them not just for exams, but for practice itself. The lectures are very practical, and they deal with practical aspects of what happens in practice in a particular subject. We also have examinations on the main, for example, we have a subject called BBST, which is usually at the end of the program, that assists students to prepare in a similar fashion for paper 1 of the boards. Okay, and we do wills and estates, which is also, I think, paper 2 of the examination. So we do try as far as possible to prepare them. We also have what we used to call attorneys bookkeeping. Previously, it's still an examination subject for our students. So that is also part of preparation for the examinations. With regard to the ethics section, it's run throughout our program. So whether you are doing magistrates court practice or the instructor is doing criminal court practice, they bring in the element of ethics throughout the program. And with regard to the quality of lectures improving, during lockdown, well, the recent lockdown, we had to go online. I know Johannesburg, we had to go online to present lectures. However, sorry, I'm not sure if you can hear me, because I think, sorry, Krish,
I think Emil has his microphone on, but he stepped out of his office and his door is open.
Okay, so recently, I would say in the past 3 to 4 weeks, we started doing online lectures with instructors being present. And that, it was successful to a certain extent, but I think only once they write examinations, I would know how effective it really has been. I find that the students are a bit shy in asking questions online. So you can't beat the contact session of lectures with students for them to benefit the most. I was fortunate enough in assisting the courses in doing one of the subjects online, and I find students are not as interactive as they would have been had they been a contact lecture. Quality of lecturing always needs to improve, and when we do the quality assurance evaluations of instructors at the end of each lecture, it's a good indication for the school principals to also see whether the instructor has been effective or not. I'm fortunate, being in Johannesburg, I usually have a pool of instructors per subject. So if an instructor has not been effective, we move or use someone else from our pool, and I usually have a one-on-one session with the instructor on how to improve with their lecturing. And I find it usually does help. And if they work with slides, for example, it usually helps. And I usually find talking to an instructor on where I think they may be lacking based on the evaluations, they usually improve. I'm not sure if there's anything else anyone would like to ask me. I'm willing to answer to it.
No, thank you very much for all of that, and all the points I'm sure will be noted and taken forward. I know we are heading towards the end of this webinar. Before I take Emil's hand, I just want to say that I would ask persons to look at the chat. There are some important comments, some answers, some questions, etc. I don't think we have a chance to go into everything, but maybe before I get back to Emil, let me take Desiree again, because I think you may want to respond to something, Desiree.
Yes, thanks so much, Trish. I just wanted to add to something to what Chandika has said. I think one of the things that look, the students that are presently at our night school, well, at the schools, would be the first bunch of students that have had to contend with the online learning that the universities had to go through last year. I think up to last year, everybody who'd been at our schools and who'd been on the course would have been seated in a traditional classroom with the contact with the lecturer. So that's the only type of learning that the student would have been accustomed to. I know some of the universities had moved into blended learning prior to the changes we had to make with COVID last year. I think from the point of view of the students, their only experience has been the traditional classroom situation with an instructor and so on. So I think for instructors as well as, and in Port Elizabeth, all our instructors are practitioners. It also was a little bit of a learning curve trying to now navigate this online platform and so on. I know at the university, our method of assessment has had to change as well to accommodate the online learning and assessment, because everything's gone online. So the types of assessment that we are doing, and I speak from Nelson Mandela University's point of view, just to address the issue of the standard of student or the caliber of student with regard to reading and understanding and being able to express themselves and formulate arguments and so on. I think the emphasis now at just in our law faculty seems to be more on problem solving and the practical way of doing things. So we're asking the more open-ended questions that require serious problem solving and thinking and expressing yourselves and dealing formulating an argument. I know some of us do it that way, and others at the tertiary level used other means of assessment. I think we've all had to go that way. And so I think that is a good thing necessarily for a student who's now doing the school or doing the courses, because they're being more exposed to at the university level this kind of problem solving and this kind of answering questions and so on. Also, I think for the student who's a student presently, they've now had at university this experience of online learning and so on. And so I think the shift to the what LEAD is doing with our schools and so on, the changed circumstances that we're working with in is not so much of a culture shock for the students. So I think it would be for 2021, I think it's the student themselves is more accustomed to the online platform and dealing with the e-leader and dealing with the kind of assessments and being in a position to work with the recordings that Chandika spoke about and so on as part of the materials that are available to the students. So I think there's reason to be optimistic that we are addressing some of the difficulties in a way that is beneficial to the students and that can address the function of the schools, which is to prepare our students for practice. Thanks, Krish.
Right, thank you very much, Desiree. I'm going to end with Emile and then Ogilvy and Tony. We don't have many minutes left, so Emile, you have a couple of minutes. Your microphone, please unmute yourself. Emil, we can't hear you. I don't know, Emil. Can someone unmute Emil, please?
Sorry, I missed that, Chris. I'll cut it short. Our time is short, but first of all, I've been involved with every single school we've got. I feel strongly about it, and I think we must be very clear. The schools do not prepare students for the examination, and it's not their function. The same with the PVT courses. We must prepare candidates for practice. Even if they attend school, they've still got to do their year of articles. Practice is the thing. But the manuals are tremendously important. And I would just stress that all the lecturers must be invited to comment on the manuals. The manuals must be completely up to date. And principals of the schools must please ensure that the instructors assist in that regard. Something else that was raised is the syllabus. In fact, apart from the prescriptions in the Act, the syllabus is reviewed every year. And my experience has been over the last 15 years that I think 90% of the amendments that have been made came from myself and Ashwin Trikamji. Somehow it gets ignored. And it's important. I think people in practice should forever be pointing out new items that should be tested in the admission exam. One of the things that was recently added under the new Act was labour law. Under the old Attorneys Act, labour law was not allowed to be asked in the exam. It's only under the new Act. So that must be done every year. As regards the statistics, we in the northern provinces actually did keep stats of the students in 16 different areas in the old northern provinces. So we knew exactly where it was good, where it was bad, and it doesn't tell you a great deal, I'm afraid. We also took statistics for a year on how the products of various universities performed in the exam, and you don't want to know those figures. We had to stop it because it would be embarrassing. Finally, Krish, I think the schools are so important. We must rely on our principals to egg on the instructors to be aware of what is coming in the exam, even if they're not preparing for them. They are in a position to make sure that at least the students have got a fair chance. We all know what happens in practice. Just after they've been at school, they do very well in the written exam and fail the oral. You still need to be exposed to practice. Sorry, I put this very quickly. I hope it makes sense to you, Chris and the others. Thank you.
Well, thank you very much, Emil. Everything you say from your long years of experience are all valuable, and I'm sure they're being noted and will be followed up. I think we would probably debate some of these things further as well. Just to make a point that with COVID and vaccination rollout, I'm sure we can only hope that there would be a better form of blended learning, possibly with schools opening up in a better way, but let's wait and see. So I want to end with just comments from Ogilvy and Tony, please. Ogilvy?
Thanks, Krish. I just want to say that we, as LEAD, appreciate all the input received today. And we will collate all the questions, everything that had to do with today's webinar. We'll put it in a document and let that be the basis of our follow-up webinars that we will have. We will correct the stats and of the 4 exams and circulate them or make them available on our LSSA website. One thing also that I want to add was that we requested the provincial stats from the LPC, but at the time we didn't receive this information. So we will also make this information available on our website or even circulate it to the delegates. I would like to thank you, Krish, for facilitating this webinar, and to also thank all the delegates who have set aside their time not only to attend and also to make input to ensure that we improve whatever that needs to be improved with regard to legal education at our schools for legal practice and also at our courses, our 23-day courses. And I'd like to say that please, if ever there's any query that you have, any comment that you still want to make after this meeting, please feel free to forward it to me so that I can include it in as part of the document that we'll put together. And I also want to say, at any time, if ever there's anything that you are not sure of, anything that you feel you want to raise, please feel free to contact me so that we can try and improve training at our schools. So from my side, I'd like to say thank you to each and every one of you. Thanks, Krish.
Thank you very much, Ogilvy. I know you have a lot of work to do, a big task, but you carry a big responsibility, and I'm sure we're all there to help to make it work. Tony, you have the floor.
Thank you, Mr. Chair. Just quickly to say that the schools take up 40% of the candidates, 60% plus of the candidates come from PVT contracts. And as many of the comments here, we will implement where we can, and we will engage with members without waiting for the next meeting. We've got the contact details of everybody who has joined, and we will share that, and we will have a follow-up meeting to measure the progress and to see what challenges remain. And we will also need to engage with the LPC, Mr. Chair, because there's one thing that I want to repeat that we have identified at the LSSA, that when you cut the budget and you reduce the hours, it does reduce the quality of training. The fallacy that you can deliver the same product with a 25% cut recently and previous cuts, there is an impact on the profession. And I'd like to thank all the instructors, all the presenters who are here today. They've continued to support the profession. And on behalf of the LSSA, we'd like to thank them that with all these challenges and COVID on top of it, many of our members, and I'm just using Emil and Andre and Franz Haupt, who I know, Etienne and yourself, and even TT, that, you know, the contribution by the profession can never be overestimated. It's always underestimated. But just to say thank you on behalf of the LSSA and the profession for the continued commitment of all the people around this webinar today. Thank you, Mr. Chair.
Thank you very much, Tony. You've covered a lot of the thank yous that I would have wanted to make to the participants and the contributions. So I won't repeat them, just to endorse all of them. And thank Grace for putting this webinar and arranging all the technical presentations and the sharing of screens and cutting off microphones, etc., with very good efficiency. Thank you very much, and thank you all for your participation and the time that you gave us. And I'm sure we will meet again with a more focused process following on what we have now had today. Thank you, Tony and Ogilvy again, and thank you, everybody.
Thank you, Chair.
Well, stay safe.
Go well.
Thank you.
Thanks. Bye-bye.
Thank you. Bye.